Okay, so we're just going to give people some time to get in, to get situated and settled, uh, get some coffee, and then we will start. Chris, is it Shapar? Thank you. Thank you for saying that on two counts. One, I had someone complain to me about the tone of today's essay. So thank you for saying you liked it. And second, also for acknowledging that, yeah, we talked about this 2 weeks ago when the judge issued the same day. I mean, the judge issued her order on July 13th, and I immediately got that out to you guys because, you guys want timely news. So thank you, Robin. I do too. Um, Jenny, I don't know if Jason wants to share his particular situation, but I know it's similar to mine. So I can tell you that in my case, because of my rare immune condition, if I am exposed to COVID, it can be fatal for me. So, that means, COVID is everywhere. People are walking around with it and thinking it's not a big deal. And so, again, I'm not Jason, but I can just share something that would look like. Shannon, who would complain? Well, let me just tell you that the person that complained is no longer following me, and that was my choice. Ah. Yep, Shannon, and again, for both Shannon and Jason and anyone else who is truly isolating and completely alone, you don't have another human being living with you, and you're not going out indoors in public except for medical appointments. I founded this very small Facebook group for people who are living like we do. I mean, we're the only people who get it. Other people who are having to do this, and we have a weekly Zoom it's on Sundays. It's a social Zoom. It's so great just hanging out with other people who completely understand. So, Robin, okay, I'm sorry to see that, but again, any of you, um, please, Shannon, Robin, Jenny, no, not Jenny, Jason. It's a Facebook group, so you do have to still be on Facebook. It's called, um, oh, what is it called? Hang on, and I will let you know. It's kind of I founded it, I should remember what it's called, but there are a lot of COVID-related groups. Okay, it's called COVIDing, like a verb, COVIDing, it alone dash still isolating. So COVIDing it alone, still isolating, and if you want to go there and, you have to apply to join the group, but, very happy to have you join us. Here, I'll put it, let's see, "COVIDing it alone." Okay, I just put the name of the Facebook group in the chat. So, the Niners-Raiders game. Jenny, you've reminded me that I went to law school in '89, and I moved to California from Buffalo, and I am not really a sports buff, but that year, the 49ers and the Bills were in Super Bowl, if I recall correctly. It was either that or they were, Buffalo and San Francisco were head-to-heading in baseball. Like I said, I'm not a sports person, but I was so conflicted. So, I do not know what Grand Tifa is, so, Teresa, I need you to explain. And we're gonna get started in just a minute with the actual topic, guys. I'm waiting for people to be able to come in and yeah. Plus, I actually just love chatting with you guys. You guys make my isolation much easier. So thank you. Huh. Well, I'm not sure I'm down with that. I am grandmother age, but that's certainly not how I identify. Ah, Jordan, just to be clear, because I can only see your tiny little profile picture. This is Jordan, the stand-up lawyer, right? Making sure. Or is it a different Jordan? Oh, okay. Then I'm really glad that I asked, and thank you so much for the kind words. The Gray Panthers, there you go. Ah, okay. Okay, Jordan. Well, welcome from Alabama. All right, well, let's get going. So, what I'm going to do, let me explain it to you. What I'm going to do today is I'm going to explain to you exactly why the immunity from the IRS, audits that was purported to be extended to Trump and his family is, as I put it, kaput. And I'm going to do that now. If you're a notes from the front member, then I actually sent the order 2 weeks ago to you, but I resent it this morning along with the claimed immunity document so that you can, uh, read them side by side, follow along with me, whatever the case may be. Oh, why are we saying yay, Jenny? Let me look very quickly. Jenny, that's the one thing about this. There we go. Oh, I don't think you're cheering her planning. Oh, well, okay. All right. Well, I can't see why Jinx is saying yay to Jenny, but there you go. Okay. So I'm going to pull up the order, and actually, I'm going to read. It's a very, very short document, the immunity document. So I'm going to read that to you, and here we go. Are you ready? This is very important to note. It starts out referencing the settlement agreement. Okay, that was the purported document that Trump tried to slip in a- as if it had been part of the court record by putting the court caption at the top. The caption, again, is that place where it says who are the parties, which court it's in, etc. So, to remind you, Trump filed a motion to dismiss his lawsuit against the IRS with prejudice, which, as we have discussed ad nauseum, is very unusual for a plaintiff to request that. But he filed it, and it was dismissed on either May 17th or May 18th. And the court, in granting that motion, made a very big point of saying very clearly, in many different ways, there was no settlement in this case. There never was a settlement. There had not even been settlement discussions brought to the court's attention. And she did that because she understood that this was some sort of hinky maneuver. Yes, hinky, that's a legal term. Not really hinky maneuver to try and put one over and to try to basically, and in her order, she calls it out, collude between the IRS and Trump in order to provide him with this purported immunity and also to create that anti-weaponization fund. So here is the entire thing about immunity that this was issued on May 19th. So 1 or 2 days after the case had already been dismissed. The settlement agreement in Trump v. IRS has created the anti-weaponization fund. The settlement agreement directed the Attorney General to issue an order establishing funding and any other relevant requirements for the fund. Now, it's very important that you understand that the settlement agreement this is referring to was that hinky settlement agreement that, in fact, the court is going to strike down in full. But we don't know that yet, right, on May 19th. So The United States releases, waives, acquits, and forever discharges each of the plaintiffs from and is hereby forever barred and precluded from prosecuting or pursuing any and all claims, counterclaims, causes of action, appeals, or requests for any relief, including injunctive relief, monetary relief, like on clearly Blanche went to ChatGPT and asked for a list of every single synonym for these things or any possible thing that could come back to them. Uh, let's see, debt relief costs, attorney's fees, expenses, and or interest, whether presently known or unknown, that as of the effective date of the settlement agreement have been or could have been asserted by defendants against any of the plaintiffs or related or affiliated individuals, including without limitation family or others filing jointly, or parties including trust, parents, sister, or related companies, affiliates, and subsidiaries by reason of, with respect to, in connection with, or which arise out of 1. Any matters that were raised or could have been raised in the case or the pending agency claims. 2. Lawfare or weaponization. Or 3. Any matters currently pending or that could be pending, including tax returns filed before the effective date, before defendants or other agencies or departments. And then it is signed by and only by Todd Blanche, Acting Attorney General. Okay, so, and when Shannon is asking, can he lie like that? And then Chris says, who will stop him? We will talk about that in a minute. So put a pin in that and remind me. That is the document. This is the notorious IRS amnesty document. This is, okay, as a lawyer and a law professor and someone who has not only been construing law for decades, but who has even written law, this thing is ridiculous. This thing made my eyes glaze over, and if this is what you call throwing everything at the wall in case something sticks. And like I said, I'm pretty sure Blanche just went to ChatGPT and said, hey, give me a list of anything that could be anything, and then format it as a paragraph, and I'll put a couple of words in there, and Bob's your uncle. So, Jenny, you have the document in your inbox if you're a Notes from the Front member, so you can read it. Anyway, so this is the purported IRS immunity document. Now, it's only signed by Blanche, which means that even if it were a thing that could stand up in court, it can't stand up on its own because it's only signed by one person. It is not an agreement. But this is what we call incorporated by reference into the purported actual settlement agreement. The settlement agreement itself came out, one of these came out one day and one came the next. And I forget which way it was, but they both came out after the lawsuit was dismissed. And again, the judge kept saying there is no settlement. There had been no settlement discussions. She made a point of putting that in her order when she, granted the motion to dismiss. And then again, after that, well after the court had dismissed the lawsuit, so the lawsuit it no longer existed. Then after that came this settlement document, which had, again, at the top of it, the caption from the court. In other words, they tried to make it look like it was an official court document when it wasn't. And thank goodness for Judge Williams for recognizing that they were trying to perpetrate some sort of fraud on the court, which she also called out in her July 13th order, because again, she was so clear for the record, which of course, now he's appealed this. Of course he's appealed it. That's what you do. You always appeal, right? Um, she put that on the record in her order dismissing the lawsuit, specifically among other things, so that when an appeals court would look at it, they would see that she had made a point of saying, "There's no settlement. There have been no settlement discussions." And then here comes Trump trying to make this bogus settlement look like it had been through the court process. So, that is the stage that is set, that she has dismissed this lawsuit, and then he comes up with this settlement document, and that settlement document, the IRS amnesty document is, adjacent and sort of an addendum to the settlement agreement. So it's incorporated into the settlement agreement, which you see here, the very first paragraph of the amnesty document says, "The settlement agreement in this case has created the anti-weaponization fund," et cetera, et cetera. So it refers to that settlement agreement. Then, a couple of weeks later, maybe a week later, those 35 former federal judges file a non-party, essentially a motion in the dismissed lawsuit, underneath the dismissed lawsuit, asking Judge Williams to reopen the lawsuit. Incredibly unusual, but because they are seeing that Trump is basically trying to defraud the courts and use the judicial system for improper gain. So she reopens it. All right. Are you all with me so far? Let's see. Not sure I should tell him if it's a Trump. Okay. All right. So hang on. Let me recharge. Okay. So Judge Williams reopens the case. And on July 13th, she issues her order. Hang on, let me pull that up. Now, I'm obviously not going to read the entire thing to you because it's a 56-page order, but I highly recommend that you do read it, or at least skim it. A lot of it is pretty clear. I think it's in pretty plain English. Let me just say that if you are not a paid notes from the front member, which is that $5 a month membership, if you want to join just so that you can get these documents and then cancel, I'm fine with that. It'll be $5 out of your pocket, but that does help. You do know at this point that I have a massive coffee habit, and it helps keep me in coffee. It helps me purchase documents. It helps me find documents, even if they don't need to be purchased. No. Anyway, my whole point is that I really recommend you reading this order because you will be able to understand it, especially if you've been with me for a while, and so that sort of know some of this stuff now. But where I want to draw your attention is that Judge Williams specifically speaks to and I have to search so I can get to hang on. Okay. I'm gonna, like, hunt and peck here because there are a few different things I wanna bring to your attention. First of all, Judge Williams points out that on June 2nd, 2026, in testimony before the House of Representatives, Blanche advised that the anti-weaponization fund would be terminated. Hang on. And would not be moving forward. He did not, however, commit to a similar termination of the audit and immunity protections set forth in his release order. 6 days later, President Trump nominated Mr. Blanche to permanently serve as Attorney General of the United States. And then we go down to here. Uh, just hang on with me. Okay. I guess I kind of need to read the whole thing, and I apologize for that. And actually, we need to do a quick review of Article 3. So let me pull that up. So, who here has memorized Article 3 of our Constitution? I have not. Uh, but I can definitely tell you what it is, but I really want to. Article 3 is the the article that basically sets up the court system. And Article 3, I'm going to read it to you, says that the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. The judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, and treaties made or shall be made under their authority. I'm obviously skipping because it's much longer than this. Um, And really, that's the relevant part. So, basically, when, in a case such as this, the order is referring to their Article 3 jurisdiction, that's what the court is talking about. So, uh, the court says that in the order, "At first glance, the complaint," meaning what Trump filed, "seemingly satisfies Article 3 by establishing causes of action arising under the laws of the United States. However, closer examination reveals that a justiciable case or controversy, meaning, something that can actually be decided by the court, there's an actual dispute, there has to be a dispute to go to court, right? Uh, Closer examination reveals that a justiciable case or controversy is absent. Plaintiffs and defendants are not adverse, because one party controls this entire litigation. I added entire for your benefit because that's what she means. So in reaching this conclusion, the court determines that plaintiffs, Trump, improperly employed this lawsuit to justify a particular award in this matter, access to taxpayer funds, and exemption from audits and other investigations, which was accomplished by leveraging control over the defendants. Okay, I'm going to let that land. Okay, this is the court, the judge, starting, let's see, probably all the people in the government have make sure that this. Okay, so President Trump is the chief of the executive branch. And the vesting clause, in other words, what vests to him, is the bedrock of his authority over that branch of government. The vesting clause states that the executive power shall be vested in a president of the United States. The president cannot delegate ultimate responsibility or the active obligation to supervise that goes with it, because Article 2 makes a single president responsible for the actions of the executive branch. Okay, here she's pointing out that Trump is responsible for his misdeeds. Here, defendants are the Treasury Department, an executive agency, and the IRS, the largest bureau of the Treasury Department. Both defendants are unquestionably part of the executive branch and ultimately answer to Trump. President Trump's authority to appoint and remove federal officers as he sees fit is evidence of his ability to exercise control over defendants, in other words, the IRS and the Treasury Department. So she's setting it up because she's going to knock it down. Okay, I'm going to jump way ahead. She talks about his control over Scott Bessant. Let's see. Okay. And then she gets to this. Let's see. The gravamen of the settlement agreement is to fund claims premised on events, including those arising from, among others, the Mar-a-Lago documents, case and the events of January 6, 2021. Indeed, these two cases have been referenced as quintessential anti weaponization and lawfare claims. Instead of either recusing because of their previous representations or vigorously defending this lawsuit as required to do so by DOJ policies and procedures, these lawyers, meaning the DOJ, who is supposed to be defending the IRS against this, these lawyers agreed to a quote unquote settlement involving a staggering amount of money, potentially benefiting former clients. And then here we go. Moreover, the release order, signed only by Blanche, extends a blanket grant of immunity to all plaintiffs and their families and quote unquote affiliates, and provides all current or possible, or I'm sorry, and precludes all current or possible investigations or actions before any other agencies or departments. The release order also purports to bar the IRS from conducting any future tax audits of President Trump, his sons, and their entities. This provision directly contravenes 26 USC section 7217, which is the federal law titled, ready? Prohibition on executive branch influence over taxpayer audits and other investigations. Let that land again. Okay. All right. And welcome everybody. Okay. All right. Let's all make sure that we're uh let's pay attention to let's read Jason's what he just put out so that we can give it that attention and then we're not distracted. Uh Yeah, that sounds really bad. Caller ID, Jason, and as you may know, this is actually one of my areas of expertise is internet scams, which that most assuredly is because I'm sure they're using a phone dialer through VoIP. Anyway, yeah, you can't trust your caller ID anymore. Certainly not for those things. If your bank wants to reach you, they'll leave you a message if it's really the bank calling. So, okay. Oh, okay, Jason. Well, then you know, which surprises me that you answered it then, but maybe you like to. Well, Jason, honestly, I have no idea how far back I need to repeat. So I'm sorry. But what I am going to repeat is that this part right here. And everybody who just joined us, we're going over the court order, which was issued 2 weeks ago, which basically voided the IRS immunity thing, but apparently people still don't realize that because the Blanche's written statement yesterday saying that the anti-weaponization fund was not going to go forward caused a whole lot of people to still be freaking out over what they believe is a still live IRS immunity order, and it is not live. It was killed 2 weeks ago. And so here we go. And now I'm reading from the actual court order from 2 weeks ago. Moreover, the release order signed only by Acting Attorney General Blanche extends a blanket grant of immunity to all plaintiffs and their families and affiliates and precludes all current or possible investigations or actions before any other agencies or departments. The release order also purports to bar the IRS from conducting any future tax audits of President Trump, his sons, and their entities. This provision directly contravenes federal law, specifically the law 26 USC, which has the title, ready? Listen to the title. Prohibition on executive branch influence over taxpayer audits and other investigations. Okay. It was so important that there is a federal law expressly prohibiting exactly what Trump was trying to do. Okay. No, no, they don't have to sign that document. Again, people, I cannot impress upon you enough, and I'm not talking about myself, but only get your information, particularly when it comes to the courts in this administration and the law, from credible uh, people who have the credentials, the background, and the expertise. For example, Heather Cox Richardson and Jay Quo and Glenn Kirshner. I mean, if you get there's just so much misinformation out there. And I promise you that if you stop following social media accounts that are anonymous, meaning all those alt accounts and, whatever accounts that don't have an actual individual as the named person for the account so that the buck stops with them. If you just stop following those accounts, the anonymous ones, your life will be so much happier and also so much more full of accurate information. Yeah, Aaron, etc. So anyway, here is what that federal law that the court that Judge Williams is citing says, quote, "It shall be unlawful for any applicable person to request directly or indirectly any officer or employee of the IRS to conduct or terminate an audit or other investigation of any particular taxpayer with respect to the tax liability of such taxpayer. The explicit, here's the court again, the explicit text of this statute prohibits President Trump and his lawyers, one of whom was former White House counsel, from asking for or promoting termination of an audit directed towards him. And acquiescing to any such demand is wholly incompatible with the duties of DOJ lawyers as well as the CEO of the IRS to enforce the law and protect the public interest. Moreover, the conferral of possibly millions of dollars in tax relief and corollary benefits potentially violates Article 2 of the Constitution, a limitation surely known by former White House counsel and the current acting attorney general. Now, this is only page 35 of a 56-page order. But let me impress upon you the importance of this, because not only was what they were trying to do illegal, but it is a tenet and just a well-established aspect of the law. An agreement to break the law is on its face void. This is the point in this court order and opinion. This is the point that kills the IRS immunity. And now I'm going to take a drink of coffee and just look at the chat because you guys are really chatty today. Yeah, Chris, sorry. I don't even know who Ben is, but he's wrong. You don't have to rescind. You actually don't have to rescind an order if the order is on its face illegal. You don't have to sign it to say, I agree with this agreement, because it just, again, this the settlement agreement and particularly the IRS immunity were never live. They were never going to be legally active or legally put into effect. And the lawyers all know this. If you are listening to someone who's a lawyer who is saying otherwise, then, send them to me because I question their credentials. So, uh, now, some of you are saying, well, he could always just reanimate it. He could do another one. Yeah, maybe he could, and that will get smacked down too. But that is not what this is about. So, um, so for the people there in the chat who are saying that, some of you have already heard me say this, but there is no point in future tripping, right? He could do anything. It doesn't mean he'll get away with it. He could also die tomorrow. He could also, be have photos released of him dressed up like the Queen of England. I mean, the possibilities for what someone could do tomorrow, later today, next week are endless. And you just make yourself crazy if you let that live in your head. So you're letting him live in your head. And I have a huge amount of faith, and it has been demonstrated time and again that my faith is well placed in our court system. Our courts are they're holding the line. They are the guardrails, and they are being very effective. Yes, he appeals everything. Guess what? That is what you do. Whether you're the plaintiff or the defendant in a case, generally speaking, you're going to appeal it. It's very important to remember, this is so important, again, that appeals like that are administrative. They're about procedural, they're about process. They are not about the merits of the case. So sure, let them appeal. Honestly, it would be considered, I think, at this point in the practice of law, to be malpractice to not appeal something. But, this is the law as it stands. This is the court order as it stands. And in this particular case, they can't really appeal. Like, the Court of Appeals is not going to say, oh, well, it breaks the law, but hey, we're going to let you do it. That's just not going to happen. So, um, anyway. It would be Shannon, that is such a broad question. Shannon's asking it would be illegal for Congress to do it also. I mean, to do what and what would it look like? This is the reason that lawyers, when asked for opinions, will say, well, it depends, or these sorts of things, because people think they're asking a clear yes and no question when really there are so many different factors that it depends on. So, could Congress pass a law that contravenes the Constitution? No. When they appeal, they always have to appeal to a higher court. That's exactly what an appeal is. An appeal is to the court above the lower court. The lower court, the court of first impression, is what is also called the trial court. In the federal system, that's the district court. So the district court issues an order, and then they appeal it to the intermediate court. So that's up the chain to the Court of Appeals. And then with this administration, they also, when they say appeal to the Supreme Court, what they're actually doing is asking the Supreme Court to hear it. The Supreme Court doesn't have to hear it. But anyway, uh, okay. So it's not a silly question. The question is, the answer, love conquers hate, is it depends. They can ask the Supreme Court to hear it. That doesn't mean the Supreme Court will hear it. And for people who have been with me for a while, that is known as a writ of certiorari. That's what the application to the Supreme Court is called. And what does it mean if the Supreme Court denies cert, or better put, what does it not mean when the Supreme Court denies cert? Because this is so important and so much misinformation out there. I'm going to not wait for you guys to answer, but if the Supreme Court denies cert, which means denying review, cert is short for certiorari, it doesn't mean anything at all about the merits of the case. It just means that the Supreme Court, for whatever reason, decided to not review it. It is not ever, ever a comment about the merits of the case. An inference about the merits of the case cannot be drawn from that. So, okay. So anyway, we're now Judge Williams has set up the reason that the IRS immunity thing simply is a non-starter. It is void. It is moot. It is kaput. It is dead because it contravenes federal law. And again, you cannot agree to break the law. But I'm also going to go back to the bottom at the end, towards the end of the order. And again, this is in your inbox, notes from the front members, because this is also the order in which she spanks all the lawyers, and I just need to find it here. Let's see. So first she says, towards the end, "The parties used the existence of federal litigation as a means of conferring, legitimacy upon a course of action that they were unwilling to subject to judicial review. In the context of the quote unquote settlement, the relationships of the people involved in negotiating and approving it, the ethical implications of their conduct, and the parties' swift efforts to dismiss this case after the court raised fundamental jurisdictional questions all support the conclusion that they were, and I'm going to say colluding. She says it elsewhere. The conclusion she reaches is that they were colluding. It was bad faith. It is, there's no validity to any of the settlement or the IRS immunity case. And then she says, accordingly, the court expressly finds that plaintiffs acted in bad faith. That's huge. That is basically, you guys tried to defraud the court. And so she's talking about how she could give monetary sanctions, but the conclusion is, and I'm just going to read this full conclusion, it's not very long. So I'm quoting the court's conclusion in this order. John Adams warned, quote, "Facts are stubborn things, and whatever may be our wishes, our inclinations, or the dictates of our passions, they cannot alter the state of facts and evidence." End of quote. Thus, whatever may be the parties' wishes, inclinations, or the dictates of their passion, they cannot alter the state of the facts or evade the rule of law. Contrary to the plaintiffs, and that's Trump, contrary to the plaintiff's concern, the court did not have to sally forth to look for a wrong to right. The court need only look to the uncontroverted facts here, which are Donald Trump is president. President Trump controls the actions of the Secretary of the Treasury Department, Scott Bessent, IRS CEO Frank Bisignano, I don't know how to pronounce that, and all executive branch actors. President Trump, through executive order at Section 7, also controls the litigation strategy and interpretation of the laws guiding the Department of Justice. For the 109 days that this case was pending before it was dismissed, no attorney representing the United States, in other words, the defendants, filed a notice of appearance or any document indicating the government's position, interest, or awareness of this matter. In other words, the IRS and the Treasury Department simply didn't respond. And in fact, at some point, had that been the case in a legitimate lawsuit, it would have just defaulted and the plaintiff would have gotten anything they wanted. But that isn't what happened here. These facts lead to the inexorable conclusion that the quote unquote settlement terms, the individuals who signed that settlement, as well as the putative beneficiaries of the, again in quotes, settlement, demonstrate a shared interest. And the unilateral revision and renunciation of the quote fund, close quote, component of the settlement demonstrate the fact that all parties were aligned and ultimately undifferentiated. In other words, she's saying, you guys were colluding. There was no actual controversy. You are not adverse parties. You are in this thing together. The nature, and now I'm quoting again, the nature of the suit itself and the conduct of the parties and counsel from its filing make plain that this was an attempt to use the court to provide some legitimacy to an agreement to confer immunity to people and entities affiliated with the president and to earmark billions of dollars from American taxpayers to redress grievances not defined in the law. The president may be the functional dominus litis. Uh, I actually don't know what that means off the top of my head. I've always seen it used as, the top guy, the litmus test of the executive branch. But as a party to a civil suit, he, as well as all the parties and lawyers before a court, are bound by the rules. Ensuring that our courts are used only for the express purpose created by the Constitution is the obligation of every judge, and an obligation that this court must discharge in light of the matter before it. In sum, the facts before this court demonstrate there was never adverseness between the parties. There was never a case or controversy, and there was never a question as to who would prevail. And then she orders, let me see if I can find the exact, let's see. Plaintiff's attorney Alejandro Brito, who is all over a lot of the Trump's motions, is referred to the Florida bar for its consideration, review, and determination as to whether any disciplinary action is appropriate in light of the findings and rulings made in this order. All future applications by Daniel Epstein for admission pro hoc vice. Okay, Epstein is from Texas. He's a lawyer they brought in from Texas. He does not have a license to practice law in Florida. And so, in those instances, what you do is you apply to be allowed as a lawyer to just work on the one case in the state where you're not barred. And that's called pro hoc vice. All applications by Epstein for pro hoc vice in the Southern District of Florida will be denied for 1 year or until further order of this court. In other words, he is barred from becoming essentially a visiting lawyer in the court. And then somewhere she also refers Blanche, but I'm going to have to find that. So hang on one moment, because I really want to read this to you, and then we'll be done. Okay. Okay, I can't find it now, but she also directs the clerk of court to make sure to notify New York about this order. So I don't want to keep you for too much longer. Oh, wait. Did I find it? Okay. Yep. The clerk of court is directed to mail a copy of this order to the New York State Bar, of which Acting Attorney General Blanche is a member, and to the District of Columbia Bar, of which Associate Attorney General Woodward is a member, where disciplinary proceedings are currently ongoing. So, in other words, Blanche and Woodward are already before their respective bars uh, for disciplinary proceedings. And so she's making sure that they also are aware of this egregious attempt to perpetrate a fraud on the court by Blanche and Woodward. Okay, so I'm looking at the chat, seeing what's going on. Yeah, that's true. Citibank. In fact, I have that open to possibly write about it. That Citibank. It was revealed just recently that in 2021 they closed all of Trump's accounts because of an inference of money laundering. So, okay. Or was it Capital One? Yeah, I don't have it open in front of me, I just have it open in a tab. Yeah, Chris, I mean, I agree, he and who darn it, I heard someone being interviewed, an attorney who had worked with Blanche years ago and said back then he was conscientious, he was thoughtful, and that she really didn't know what had happened. Okay, Jenny, what did you just hear about this morning from Aaron? I assume you mean Aaron and not Lev. All right. Anyway, does anybody have a question about the topic at hand? Okay, what did people hear? Oh, I'm seeing a whole lot of people saying they heard about something, and I'm not seeing what they heard about. Are you talking about you heard about the bank closing his accounts and then he sued and now discovery may happen? Is that what you're talking about? Okay, right. Yeah, well, also remember that the court, and I wrote about this last week, he sued the BBC for defamation, and he probably didn't think about the fact that he wasn't going to be able to leverage the FCC over them and force them to settle. So they're moving forward, and the court just ordered that the BBC is entitled to discovery in that case as well. Do I think there was Well, Deborah, I think that so she's asking if the respective bar associations will look into these things. And yes, I do think that. I don't know that they what they will do about it. But when you get a referral to the bar for discipline, especially coming from a federal judge, yeah, they will look into it. Okay. All right. Well, we're coming up on just about having been going for an hour. So I'm just going to leave this open for a few more minutes because I really enjoy interacting with you guys. And plus, I want to see if I've missed anything really, any super important questions. All of your questions are important, but um, I want to see if there's anything that needs answering. Laura, not Loomer. And thank you for saying. I do wanna point something out, because those of you who are saying that Capital One, the Discovery is gonna he that he didn't think about Discovery happening and also the same with the BBC. I want to point out that and some of you have heard me say this before, that I think, for example, with the BBC, that Trump may now try to, file a motion to dismiss the case because he's the plaintiff, so he can file that motion. And that may happen in the Capital One case as well. But what's important is that he has to file a motion requesting permission from the court to close the case. It isn't automatic. And the court can deny that request. If the court feels that the defendants, that the case has gone far enough that to dismiss the case would prejudice the defendants, the court can deny Trump's request to dismiss the case and can order, that discovery go forward. And I would love that for him. And I think that that may happen. Uh-oh, did I freeze? This would be a really good time, I guess, to end the live. And it does look like I froze. Ugh, let me just try refreshing. Otherwise, if any of you can hear me, thank you for joining me, and I'll see you on the next live.